It'll say in a minute, it'll say breakout.
Recording in progress.
All right, the record will reflect that the defendant and his counsel returned from the breakout room before it started a few minutes ago, and so we've been able to complete your consultation, Mr. Wagner.
We have, Your Honor. And Mr. King, the issue of restitution will not be a problem.
Okay.
We're not raising it, shall I say. Okay.
All right. Mr. Arrows, you were found over the grand jury as a result of a complaint that was filed in the municipal court, Millville Municipal Court. They came over to the to the head clerk's office here on August 23rd, and at this point, the grand jury has not yet returned an indictment against you. Now, under Ohio law, no person is required to come before this court and answer to a felony until and unless they have had their case submitted to the grand jury has returned an indictment. Grand jury consists of 9 persons from this county that are selected to serve on the grand jury for a term, and this term is the October term, October, November, December. They meet usually once a month or more often if necessary to hear evidence presented to them by the prosecutor's office regarding alleged crimes committed in this county. Now, the grand jury does not decide whether the person is guilty or not guilty, they simply decide whether or not there's enough evidence to warrant a person being required to come before this court. So therefore, only 7 of 9 are required to return an indictment. Now, if fewer than 7 vote to indict, then as to that particular charge, the case is over for the time being, and you're released as to that charge. Although that's not final, because it could always be resubmitted up to the appropriate applicable statute of limitations, which generally is 6 years. So that has not happened yet in your case. Now, there is a provision, however, in the law that a person can waive, which means give up in a legal sense, the right to have their case submitted to the grand jury, and instead agree for the case to be submitted by what's called a bill of information. Now, a bill of information is similar to an indictment in that it sets forth a charge, but the difference is it's simply signed by the prosecutor's office instead of being voted on by the grand jury. And so that's where we're at this point. You're not facing any felony charges, but I have been presented with a proposed bill of information along with a proposed plea of guilty, and look here at another file I was looking at. Is there a waiver of indictment in here as well, Dylan?
Yeah, they were all paper clipped together, you know.
Well, look here, the bill of information.
I'd be on the back
There's
page.
the staple to the back of the bill of information. Got it. All right. Okay. Let's see.
What is it, Judge? Oh.
There
There you go.
Okay. All right. So, the bill of information I have in front of me, I'll hold up here, and it says your name and case number. And there are 5 counts in that. So, the bill of information alleges that in count 1, that on or about August 8, 2021 in this county, you did by force, stealth, deception, knowingly trespass on a non-occupied structure, or separately occupied portion of non-occupied structure, or purpose to commit in the structure, or separately occupied portion, a criminal offense, in violation of section 2911.12A3. That's the charge of burglary. Count 2 alleges on or about August 8, 2021 in this county, you did not, having been relieved from a liability as ORC 123.14, knowingly acquire, have, carry, or use a firearm or dangerous ordinance as defined in ORC section 2923.11 with TARS V2C 9mm handgun, and that you were under indictment for, have been convicted of a felony offense involving illegal possession, use, sale, administration, distribution, trafficking, and drug abuse, or adjudicated delinquent child commission of an offense that is committed by an adult who has been a felony offense involving illegal possession, use, sale, administration, distribution, trafficking, drug abuse, to wit, trafficking in drugs, in violation of RC section 2925.03 in Greene County Common Pleas Court on April 20, 2011. Violation of section 2923.13A3 of the Ohio Vice Code, that's having weapons under disability. Count 3 alleges on or about June 5, 2021, this county did receive, retain, dispose of certain property being a pop-up camper, property adjacent to Lore, knowing or having reason cause to believe been obtained through commission of theft offense, said property being valued at equal to or greater than $1,000, less than $7,500, that's receiving stolen property. A 5th degree felony, I believe. Count 4 alleges on or about June 5, 2021, this county you did with purpose to deprive Jason Moore of his property to obtain and exert control over said property with a 2005 Chrysler minivan, a motor vehicle, defined in ORC section 4501.01, without the consent of Jason Moore, owner, person authorized to give consent, and that's in violation of 2913.02A1, Highway Vice Code grant theft of motor vehicle. And that would be, I believe, a fourth degree felony. And then count 5 alleges on or about August 8, 2021 in this county, you had in your possession a mint green Taurus GRC TMS 42529, subject to forfeiture due to its instrumentality in commission facilitation offense, as defined under ORC 2941.14.17. That's a forfeiture specification, which means the property will be forfeited. Now, that's a proposed bill of information. And my understanding, Mr. Wagner, you've had this for a while.
Yeah, we went over at least, I don't know how long ago, Steve, but it's been a while.
All right. Now, I have your document, Mr. Arrows, is entitled Waiver of Prosecution by Indictment, and it reads, I, Steve Robert Arrows, having been informed by the court of all my constitutional rights, my right to be presented and prosecuted by way of indictment, being represented by J.D. Wagner, Attorney Law, Hillsborough, Ohio. We hereby freely and voluntarily waive prosecution by indictment and agree to proceed in this matter by bill of information, and it's dated 10/5/21. Immediately before that, there's a signature with a line under it, Defendant. And I'm going to hold this up to the camera on the computer and see if you recognize that that is your signature there right below the date.
Yes, it is, Your Honor.
All right. And I know that's Mr. Wagner's signature below. Now, this waiver then means that you're agreeing that instead of waiting for the grand jury to consider your case, which will probably be next month, you're agreeing to be prosecuted by a bill of information, which is on the 4 charges I just read plus the forfeiture specification. You understand that?
Yes, Your Honor.
And that's what you want to do.
Yes, Your Honor.
All right. Now, the next document I have is a plea of guilty form. Now, I'll hold it up to there. That is the front page, and it has 4 counts plus the forfeiture specification. You see that there?
Yes, I do, Your Honor.
All right. Sorry about the way I hold it. All right.
Your Honor.
And this is a 3-page document. On page 3, there are signature lines. Right below a sentence that says, I enter this plea voluntarily. And immediately below that is a line for signature defendant. And I'm going to hold that up to the camera and ask you if that is your signature there next to my finger that we're looking at.
Yes, it is.
And you also signed this on the 5th of October.
Yes, Your Honor.
And when you signed it, was your attorney with you there at the jail?
Yes, it was.
And did he explain all of it, go over it with you, explain it, answer any questions you had?
Yes.
And do you think you've had enough time to fully consider this matter before making the decision to sign this document and enter into this agreement?
Yes, Your Honor.
Did you enter into this agreement by signing it voluntarily?
Yes, Your Honor.
And is this still what you want to do?
It is.
All right. Then the agreement states that you're going to plead guilty to counts 1 through 5. And again, count 1 is burglary under 2911.12A3, a 3rd-degree felony. Count 2 is having weapon under disability under 29.3.13A3, revised code of 3rd-degree felony. Count 3 is receiving stolen property under 2913.51, revised code of 5th-degree felony. Count 4 is grand theft of motor vehicle under 2913.2A1, the revised code of 4th-degree felony. And count 5 is forfeiture specification under 2941.14.17. Now, on down on page 1, it indicates you understand the maximum penalties for these are as follows. Counts 1 and 2 are both 3rd-degree felonies, carrying maximum prison term of 36 months. However, there's also a minimum of 9 months, and there are different increments in between. Now, there's also a fine available of up to $10,000 on each charge. Count 3 is a 5th-degree felony, carries a maximum penalty of 12 months in prison, a minimum of 56, and there's a possible fine of $2,500. And count 4 carries a possible maximum sentence of 18 months, minimum of 6 months as well. and a fine of $5,000. And in count 5, as I indicated, doesn't carry any kind of a prison or fine, it simply loses the property to the state. Now, under the law, if you're convicted of all these offenses in order and are sentenced to prison, or the prison term to be served consecutively. So that means that with 2 counts, third-degree felonies, 36 months each. That's 72 months plus 12 on count 3 plus 18 on count 4 would be additional 30 months. That means a maximum possible of 102 months, which I believe is 8.5 years. You understand that?
Yes, Your Honor.
All right. Now, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No, Your Honor.
All right, now, under Ohio law, if you are sentenced to prison on these offenses, you are subject to being put under what's called post-release control. You need to be supervised by a parole officer in terms and conditions set by the parole authority, not the court, but the court's not involved with that. And that would be after you serve your entire prison term. Now, there's kind of a mixture here, but in this case, on count 1, it is mandatory. It should be under post-release control for at least 1 year. It could be up to 3 years. The term would be decided by the parole court. Now, on the other counts, 2, 3, and 4, it's optional, meaning it could be up to 2 years. But since count 1's mandatory, that means you'll be on for at least 1 year and up to 3 years total, as determined by the parole court. You understand that?
Yes, Your Honor.
Now, what that means is that if you violate any of the conditions that the parole authority sets forth, then they can return you to prison for an additional period of up to 9 months for one violation, but there is a cap or limit of half whatever prison term was imposed by the court for all violations. But if you commit a new felony while under post-release control, then an additional whatever sentence the judge in the new case would impose on you, that judge would also sentence you in this case for committing the new offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that term of post-release control of 1 to 3 years, whichever is greater. So if they put you on for 1 and you commit a new felony after 6 months, the additional penalty would be 1 year because that's more than 6 months. If you were on for 3 and you committed a new felony after 6 months, it would be 2.5 years because that's what's left upon 3 years of post-release control. You understand that?
Yes, Your Honor.
And again, you understand that those sentences would have to be served consecutively with sentence in the new case.
Yes.
All right. Now, under the law, these are not mandatory prison terms. I can impose what's called community control instead of prison, which means probation. And so instead of going to prison, you can put under the supervision of a probation officer under the terms set by the court. The maximum period could be 5 years. If during that period of time it was found that you failed to comply, then at that time the probation department would have to file a written notice of that in the court and give you a copy. It would be tough to have a hearing. If the outcome of that hearing was that you failed to comply, then at that time the court would revoke community control and then it would sentence you to prison for the total of 102 months and finding $27,500. You understand that?
Yes, Your Honor.
Right now, Mr. Harris, I read you the bill of information a few minutes ago. You recall those 5 charges?
Steve, you recall those charges?
Just answer, okay? All right. And you understand then what it is the state says you did in each of those counts, when, where, and how they let you did?
Yes.
Now, have you discussed the nature of the offense in each count, the evidence that might be applicable in that count, legal issues that could be considered in that count, possible offenses you might try to raise at trial, the possible outcomes of that trial as to all these charges with your attorney?
Yes, I have.
And are you satisfied with this advice and comments in this matter?
Yes.
You know, gentlemen, one thing I forgot, Mr. Weiger Are you employed?
I am, sir. His mother reached out to me.
All right, I just want to make sure that was on. All right. Okay, now, are you under the influence of any type of drugs or alcohol at this time, Mr. Harris?
No, I'm not.
Are you taking any prescription drugs there at jail?
Just penicillin for my abscess tooth.
Okay, that's not affecting your ability to understand what's going on here today, communicate, or to understand what you're reading, or anything like that?
No.
Okay. Now, has anyone threatened you in case you plead guilty here today?
No.
Now, on page 2, there are several lines that are printed in bold and underlined. I see there's been a couple of changes made in ink. But hold that up to the camera so that you can see that. You recognize that from the plea agreement you signed on the 5th.
Yes.
All right. I will read that then as it has been amended with these ink set changes. It says, Defendant shall enter plea of guilty to the bill of information. State defendant shall only recommend 24 months on count 1, consecutively 12 months on count 2, consecutively 10 months on count 3, consecutively 13 months on count 4, for a total of 59 months. And that's been changed by ink. 10 has been changed and the 60 been changed. And Mr. Wagner's initials are there to show that he made that change. Defendant agrees to forfeiture outlined in count 5. Defendant shall cooperate in the prosecution of code defendants. Now, is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, Mr. Eros, the matter of sentence is reserved to the judge, not the parties. So even though there's an agreement there that the total sentence ought to be 59 months as outlined, those sentences are not binding on the judge. So if you plead guilty, once I've heard all the information presented, I could decide those aren't the correct sentences under the law of the evidence that I could sentence you to as much as 102 months total and fine you $27,500 if I thought that was the right thing to do. You understand that?
Yes, Your Honor.
Now, the state's consulted with the various victims in these charges as well as law enforcement.
Yes, Your Honor.
They're in agreement with this disposition.
That's correct, Your Honor.
Okay. And I know there was a discussion earlier in chamber between counsel and the court about restitution and an agreement on restitution, but it's not stated in the plea agreement. Is there an agreement to pay restitution?
There is, if I may, Your Honor, when we went to the breakout room, I feel comfortable saying I discussed this issue with my client. I advised him that the number I had was $6,769.49, that through our discussions, he could disagree because some of the charges that restitution would be ordered on were not part of this plea agreement. But by us agreeing to this restitution, those various charges will not come forward. My client does agree with that. Is that correct, Steve?
Yes.
All right, well, for that to be part of the agreement, it needs to be included, so are you amending the agreement to add that?
Yes.
All right, can you give me the breakdown of the victims and the amounts, Mr. King?
Yes. So there are 5 different victims. First, we have $3,500 to Eric Callahan.
Okay.
Next, we have $650 to Tim Sweeney.
And he's not one of the victims charged?
That's correct, Your Honor.
All right.
Next, we have $2,102.38 to Joseph Ruth Jr.
Okay.
Next, we have $1,700 to Brad Miller, and that would be joint and several with Robert Woodard Jr. and Lena Henry.
Okay.
And last, we have $550 to Steve Carroll.
So, are any of these victims included then in the indictment or in the bill of information?
Mr. Miller.
Brad Miller, I believe, is the only one that's included in the bill of information.
Which count is that?
I don't have, that would be the burglary.
Count one? Alright,
Yes.
alright. Now, how much was the total? 6,769 and what?
49 cents.
Okay, well, I only have 38 cents. Got 3,500, 650,
Yeah,
2102.38, 1,700, 550. I haven't added those up, but, another 49 cents out of that.
yeah, I agree, Your Honor.
I'm not getting that amount either. I'm gonna try to get 3,500 plus 650. That's 4150. 2102.38 is 6250. 238. 1,700 to Mr. Miller.
Yep.
That's 7952.38, and 550 to Mr. Carroll. Makes it a total of 8502.38.
That's what I get.
So we're
What I got, sir?
How do we come up with 67, 69, 49?
I don't know.
Okay, well, that's honest. I think if you subtract 1,700 from that, that's probably close to 80, 60, 67, 69, 49. So that must be the amount that's above what was in the indictment that we're talking about in shape. Because 8502.38 minus is 6802.38. Because the discussion in chambers was that there would be restitution on victims that were not included in the bill of information. So the 1,700 account for is Mr. Murphy. So then the additional is 6802.38 above and beyond. Now, Mr. White, you need to talk to your client on that.
Eve, is that number still acceptable to you?
Yes.
Okay. All right, so then the agreement is, and I'm going to add in here, restitution is agreed upon as part of the agreement, including 4 victims not included in the charges in the indictment. Is that correct, Mr. White?
Yes, sir.
And so,
Yes, sir.
understanding that Mr. Arrows is in consideration of not being charged with crimes of those other victims, they're agreeing to accept, you're agreeing to pay restitution, you understand?
Yes.
Okay. All right, so what I have added then, gentlemen, is this. Defendant shall pay restitution of $1,700 to Brad Miller as to count 1 and 6,802.38 to 4 victims of crimes not being charged as consideration for plea. Is that accurate?
Yes, sir.
Yes, Your Honor. The only thing I would add is the Brad Miller and joint several with Robert Woodruff and Lena Henry.
Okay, we'll put that in the order then. All right, so Mr. Arrows, you understand what that means is that normally I wouldn't order restitution on a crime that's not charged, but when a defendant in a state enter into a plea agreement, they can make, as consideration for that, promises to do certain things, which make it binding. And so, in this case, you're agreed to pay for that restitution, and they'll exchange the state not charging you with crimes related to those, but it will still be enforceable as an order of the court in the future once you complete your sentence. You understand that?
Yes, Your Honor.
Okay. And you're agreeing with that?
Yes, Your Honor.
All right. Now, do you hold any license or certification with any state governmental agency for any kind of occupation or profession?
Like plumbing fabrication.
Well, like, a surveyor or nurse assistant, barber, things like that the state has to give you a license, you have to take an exam.
No.
Okay. Now, under the law, you have certain constitutional rights, you understand, before I can accept your plea in this case, Mr. Arrows. First, you have the right to have counsel. Mr. Wagner has been employed on your behalf. You understand that in the event that there was no one to pay for his fees, that the court would appoint one for you, so you don't have to plead guilty because you're worried about paying Mr. Wagner. You understand that?
Yes, sir.
Okay. Now, under the law, you have a right to have a jury trial in these matters, in which 12 people would be selected from a group of citizens that live in this county that were selected for jury duty on your trial, or were summoned for jury duty on your trial. 12 people would be selected from that group. The evidence would be presented, the jury would be instructed on the law. Now, that jury would have to decide by unanimous verdict, 12 after 3, on whether the state proved your guilt on any of these offenses. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing the right to have a jury trial, and in that case, you have to hold a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, the judge would be the one to decide whether or not the state proved your guilt by proving beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you have a right to cross-examine the witnesses against you in open court through your attorney and to confront them as well in open court. What that means is witnesses have to come into the courtroom and testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to bring out evidence to help your side of the case. Do you understand that?
Yes, Your Honor.
The Constitution, Mr. Arrows, you have the right to use the power of this court to compel or force witnesses to come to court to testify for you, same as the state. So if you have witnesses you're not certain going to come in voluntarily, at your request, court issues court orders called subpoena. And that forces those people to come to court to testify for you, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation. And that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter. You are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty of any of these offenses. In fact, you don't even have to put on any evidence at trial. You can, but you're not required to. But the burden of proving you're guilty will remain upon the state of Ohio. Prove your guilt on every essential element of each of these 5 offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, under the law, you have possible plea of not guilty to these charges, which means that you would deny the allegations in the information, deny you committed any crime, and that would exercise or invoke all the rights that I just described. Now, you also have the option, which is what the plea agreement provides for, to plead guilty. And what that means is that that's the opposite of not guilty plea. Guilty plea will admit the allegations in the indictment that they're a crime, that you committed that crime. That plea would waive and give up all of the rights that I've just described for you, except the right to have an attorney, because you always have a right to have an attorney no matter what the plea is. But with that exception, the plea of guilty waives gives up your right to a jury or court trial, waives gives up the right to confront witnesses against you and cross-examine through your attorney, waives gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. The waives gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. Excuse me. Now, that plea also subjects you to being sentenced immediately by the court, which I believe is what's being proposed here. And finally, it waives gives up any right to file an appeal that you feel you may have had up until this point in the case for any alleged violation of your rights. Now, should I sentence you to maximum sentence on any of these charges, or under other certain circumstances, you could file an appeal that would have to be filed within 30 days of your sentencing and should be filed. You understand all
Yes, Your Honor.
that? And are you a U.S. citizen, Mr. Harris?
Yes, I am.
Now, do you have any questions about the bill of information or waiver of the indictment or the process that's brought you here before the court today?
No, Your Honor.
You understand?
Yes, I do.
Okay. And you're still wanting to go forward in this matter?
Yes, I do.
Now, do you have any questions about the charges and the bill of information or the possible penalties?
No, Your Honor.
You understand?
Yes.
You have any questions about the plea agreement?
No,
You understand?
I understand.
You understand that the recommendation as to sentencing is not binding on the court?
Yes.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, Your Honor.
You understand?
Yes.
Now, is there anything further you would like to speak to your attorney before we go any further?
Not that I believe.
All right. Do you have any questions about anything that we've gone over here today in this plea agreement as it's been mentioned here on the record?
No, Your Honor.
All right, then is it your decision to plead guilty to the charges as set forth in the plea agreement, counts 1, 2, 3, 4, 5, as set forth in the bill of information?
Yes, Your Honor.
All right, then as to the charge in count 1, that alleges that on or about August 8, 2021 in Highland County, Ohio, you did by force, stealth, or deception, knowingly trespass in an occupied structure, or separately occupied portion of an occupied structure, purpose to commit in the structure, or separately occupied portion of a criminal offense, violation of section 2911.1283 of the Ohio Revised Code, to charge burglary, third-degree felony, or possible prison term of 29 and 36 months, in increments provided by law, a fine of $10,000, and mandatory post-release control of between 1 and 3 years. How do you plead?
Guilty.
Count 2 was alleged that on or about August 8, 2021 in Highland County, Ohio, you did, not having been relieved from liability, please tell Mrs. Collins to start just cutting and pasting instead of writing these things from scratch. She's got liability here, which should be disability. You wish to amend the indictment to set that in there.
Yes, Your Honor, thank you.
All right, Mr. Wagner, do you have any objection to that?
Your Honor, it's a scrivener's error. We have no problem, Your Honor.
All right. So, I'm writing this in my hand, so it's correct. Just another example of unforced error. Says on or about August 8, 2021 in Highland County, Ohio, Steve Robert Harris did not, having been relieved from disability, as provided in ORC 2923.14, knowingly acquire, have, carry, or use a firearm or dangerous ordinance as defined in ORC section 2923.11, to wit a Taurus G2C 9mm handgun, and it says Steve Robert Harris was under indictment for having been convicted of a felony offense involving an illegal possession, use, sale, administration, distribution, trafficking, and drug use. And we'll leave out this part's not applicable. To wit, trafficking in drugs in violation of RC section 29.5.03 in Green County, Police Court on April 20, 2011. Violation of section 29.3.1383 of the Ohio Vice Code, having a weapon under disability, a third-degree felony with the same possible prison term between 9 and 36 months up to 2 years of post-release control, which again, you're going to be on one anyway. How do you put it?
Guilty.
Count 3, which alleges on or about June 5, 2021 in this county, you did receive, retain, or dispose certain property being a pop-up camper, property of Jason Moore, knowing or had reasonable cause to believe to obtain commission of theft offense. Said property being valued at equal to or greater than $1,000 or less than $7,500 in violation of section 2913.51 of the Ohio Vice Code, received stolen property, a 10th degree felony, or possible prison term of 26 to 12 months, and fine of $25,000. How do you plead?
Guilty.
Count 4, which alleges on or about June 5, 2021 in this county, did with purpose to deprive Jason Moore of his property, knowing maintain exert control over said property to wit 2005 Chrysler minivan, motor vehicle, RC section 4501.01, without consent of Jason Moore, the owner or person authorized to give consent, in violation of section 2913.02A1 of the Ohio Vice Code, grand theft of motor vehicle, a fourth-degree felony, carrying possible prison term between 6 and 18 months, fine $5,000. How do you plead?
Guilty.
And count 5, alleged on or about August 8, 2021 in this county, getting possession a mint green Taurus GRC TMS 42529, subject to forfeiture due to this instrumentality commission facilitation offense, finding RC section 2941.14.17, which would result in forfeiture of that to law enforcement of the state. How do you plead?
Guilty.
All right. Thank you. And I don't recall, you are a U.S. citizen.
Yes.
All right, the court finds that on this day, open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver for safety pursuant to Article 11. Please accept the court 5. Defendant is found guilty of counts 1 through 5 as charged in the bill of information. Please accept the court 5. The court finds that there is an agreed sentence recommendation to the court that based upon the bill of information, he has previously been convicted of a trafficking and drug offense, and therefore the court is not going to order a pre-sentence investigation until he wants to request it. We're going to go ahead and proceed with sentencing. All right, Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the court follow the court recommendation. The forfeiture in count 5 would be to the Highland County Sheriff's Office, and in the entry I've broken down the restitution amounts owed to the affected victims. Thank you.
And a joint several for Mr. Miller is with who?
Robert Woodruff Jr. and Lena Henry, L-E-N-A.
Lena Henry.
Yes.
Right. Where?
Yes, sir, Your Honor. We would ask the court to follow the recommendations. Background of why the deal maybe was negotiated, Your Honor. The Temple Fisherman's Wharf to Mr. Miller, my client, was apprehended shortly thereafter. Feedback. After he was arrested, Your Honor, he met with the detectives and cooperated with the rest of these crimes that have been outlined, and some uncharged, some. My client spoke to Mr. Hickson several times and confessed to various crimes, which led to the recovery of some property that may or may not have led to the apprehension of the other individuals that are joint and several. So he did cooperate fully with authorities, Your Honor. I think he's very regretful. I will say the first time I met Steve, he looked like a train wreck. Looked like he'd come off of a bone bender. I've now seen probably at least half a dozen times. He's looking better each day, Your Honor. Hopefully this is a sobering moment for him. He's got some time to think about it. But again, I do believe Steve can be productive. I just think he found himself, sadly enough, in the drug addiction like we see, and he was stealing to fuel his habit, Your Honor. That's it, sir.
All right, Mr. Harris, anything you would like to say?
No, Your Honor.
Have you served time then previously on your charge back to Green County in 2011?
I did a year and a half on that charge, yes.
If you have you served in the other term since then, or before then?
No, Your Honor.
All right. All right. Well, Mr. Harris, I think your attorney's probably done a pretty good job for you in getting this agreement put together from McAfee. But I can tell you that, those other uncharged crimes have been included, certainly those will be an additional sentences, because the court's view is that each victim's charge for what somebody's a victim of deserves a separate sentence. It's not fair to victims that lump them all together and basically give the defendant a 2-for-1, 3-for-1, 4-for-1 discount. I don't do this current sentence, so he's negotiated that for you, but also as a condition of that is that you agree that you're going to make this restitution for these uncharged defendants or crimes. And so it's the order of the court that you be and are hereby sentenced to the Correctional Reception Center in Morehead, Ohio, as to count 1, burglary, for a period of 24 months, as to count 2, for a period of 12 months, as to count 3, for a period of 10 months, and as to count 4, for a total of 13 months. And it's further ordered that each of those sentences be served separately, meaning one after the other. Now, the court makes that order because of several things. First of all, these offenses committed over a period of time, separate courts of conduct for different victims, other than Mr. Moore being involved in counts 3 and 4. And one single prison term will not adequately reflect the seriousness of conduct. And the sentences are being imposed not disproportionate to the harm that's being caused by these offenses. Also, your history of criminal conduct demonstrates that these sentences are necessary to protect the public when you've had a number of victims involved. Now, it's also ordered that upon completion of this prison term, and you're notified, I should say, that she will be put on post-release control as to count 1 by the Delta Parole Authority in the terms they set for at least 1 year. It could be up to a maximum of 3 years as they determine. And if during that period of time you're being supervised, they determine that you have failed to comply, then they can return you to prison, making you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term. In this case, your prison term is 59 months, so the maximum could be 28.5 months for one or more violations. But if you did a felony, then in addition to whatever sentence, the judge in the new case would impose upon you, that judge could also sentence you for committing that crime while under post-release control, in this case, to an additional period of 1 year, whatever time might be left on the period of post-release control that was imposed, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the case. Now, based upon Court of Appeals decision in this district, which I still disagree with, even though you're mandatory on count 1, I still have to tell you that as to counts 2, 3, and 4, you could be put under post-release control for a period of up to 2 years as determined by the Adult Parole Authority. But we know you're going to be on for 1 to 3 years in count 1, and under the law, you just get one PRC sentence anyway, but that's what the Court of Appeals requires you to do. It doesn't make any sense, but that's not a usual Court of Appeals decision. It might. I don't agree, but it might. You're also ordered to pay the court costs of judgment execution order. If you fail to do that, then you could be ordered to do community service once you complete your prison term on while you're in prison. And that means that you would work in this county doing community service to give credit for each hour you work in an hourly rate set by the court. Each hour you work to reduce your judgment by that time to pay full. Now, it's also ordered that you pay restitution as a subsequent part of the sentence. And that was ordered to be, to the following individuals, $3,500 for Eric Callahan, $650 for Tim Sweeney, 21 of 238 for Joseph Jr., $1,700 for Brad Miller, which is the joint several with Robert Woodward Jr. and Lena Henry, and $550 to Steve Farrell. Now, that's a substantive order. What that means is that even if you serve your entire prison time, you don't have any prison time hanging out, you're still required to pay that. That can be enforced by various means, including bringing you back into court on contempt if the state can prove that you had money to pay and you failed to do so. And if so, then you should be put in jail for contempt. And they can also pursue you for collections. And that is not going to go away until you pay it or you die, whichever occurs first. So it's just because you do your time doesn't mean you're off the hook. It's ordered that you make those payments through the victim witness escrow account office, and the victim witness office, and it's pay the associated filing or service fee with that, which I believe right now is $5. All right. As far as jail time credit, I believe we have some jail time credit for the sheriff. We was arrested August 8th, and so as of today, that'd be 66 days. Agree with that number, Mr. Harris?
Yes.
Okay. All right, you're then remanded back to the sheriff's office or transferred to the prison system.
Oh, Your Honor,
Yes.
only thing is the forfeiture. I don't believe that
No,
was.
I did not order the forfeiture. You have your gun and count 5 is ordered before the Hyde County Sheriff's Department. Thank you. All right, I need Mr. Welch there, Deputy.
Yep.
Who's that?
Case number 21-CR-0099, State of Ohio versus James Welch Jr. Are you James Welch Jr.?
Yes, sir.
All right, Mr. Welch, you were convicted of possession of heroin and aggravated possession of methamphetamine, 53 felonies, and you were placed on community control on September the 1st of this year. There was a warrant filed for you on September 30th after the probation notified that you left the treatment facility due to COVID concerns and not return, and that was issued on the 30th of September and appeared to be apparently taken in custody over the weekend. Now, the allegations are that notification of alleged violations that was filed this morning alleged that you violated Rule 3 and that you failed to provide a valid address to your officer and required to keep informed of residence in place of one more time. And you can't change either without prior permission, so allegedly you failed to do that after you were released from the treatment facility. And then Rule 19 alleges that you failed to complete residential treatment at Woodhaven as required by the court. Now, under the law, in the event that you're found to have violated these conditions, one of 3 things can happen. I can continue to community control with the same conditions, I can continue with other conditions I think are additional conditions I think are appropriate. Or the third and the most serious is I can revoke your community control and sentence you to prison for 12 months on each charge total, 24 months and fine you $5,000. Now you are entitled to have a hearing in this matter, in which the state will be required to present evidence to prove that you're guilty of these allegations, and you're entitled to have an attorney to represent you. You cannot afford to hire an appointment for you. And are you requesting that the court appoint counsel for you? I don't have financial disclosure here.
I can't hear you.
Did you fill out a form about your finances for me to appoint counsel for you?
No.
Okay, are you requesting the court appoint counsel?
I guess.
All right. Well, officer, you'll need to have him fill out one of those forms. So, the court will go ahead and appoint Ms. Barger to represent you previously. The matter will be set for hearing on October the 27th at 1 p.m. There will be no bail, on this, you'll be held in custody pending, that hearing. And, just make sure he gets one of those financial disclosure forms, officer, and get it back sent to us, please. We'll notify your attorney of her appointment. You have any questions, Mr. Welch?
No, I didn't know if we could probably just even resolve this today.
Well, I'm gonna, since I'm gonna appoint counsel for you, we'll have to wait. But she'll get in touch with you, you can talk to her, and, she'll talk with the prosecutor.